Sure, I got nothing. I have nothing either way. I'm just going to say I have nothing. I'm going to make my motions and let's get on.
Okay.
I thought it'd be easy to find. Somewhere back at the office, I have a case. I don't know what it is. I hate it when I'm trying to do that. So I was going to say there's I hate it. I know there's a case, Judge.
Right, I understand. I understand.
Are you using my resources?
Probably, yes.
Remain seated, court's back in session.
Do you have the case?
Not only do I have one, Your Honor, do I not have one, but I don't like it when there is one. So I'm going to say I don't have one. I'm going to simply perfect my objection by saying that to say that the defense has put the victim on trial is number one, disparaging the right to cross-examination. Number two, it is a call for sympathy for the victim, which feelings of sympathy, of course, not allowed, and it is burden shifting, and that's my objection. But I don't have any case on support.
Okay, state.
I have no response. I'll be tempered.
Please stop walking the line.
Thank you, Your Honor.
Thank you. Let's go ahead and bring the jury in. And just so you know, before we stopped, you were at 52 minutes.
I'm winding down. I'm winding down.
Jurors are present.
Please be seated. Thank you, ladies and gentlemen. Mr. Stone, you may proceed.
Thank you.
Continue.
Thank you. The point is, it's Mr. Apperson who's on trial in this case. That's the point. When Mr. Apperson testified, you heard a whole bunch of things. Trayvon Martin, Samantha Shivey, Mr. Zimmerman's ex-girlfriend, the FBI, the September 11, 2014 incident, the September 9, 2014 incident. If you want to believe all of these things, then go ahead. As a matter of fact, assume it's all true. Assume it's all true. All of those things do not negate Mr. Apperson's conduct on May 11th, 2015. And if anything, they provide a motive for what he did, for shooting into George Zimmerman's truck. As I said before, by May 11, 2015, Mr. Apperson had it with Mr. Zimmerman. And what happened on May 11, 2015, the date of this crime, and the date we should focus on, was the culmination on the defendant's part, of Mr. Apperson's part, of an ongoing feud, an ongoing dispute that he had with George Zimmerman. Now, George Zimmerman is no Boy Scout. I get that, and you get that. But no matter how you feel about George Zimmerman, he can still be a victim of a crime, and he was in this case. It would be wrong, and I say this with the utmost respect, it would be wrong for you to go back and deliberate and to say, well, we don't care about George Zimmerman, or we don't like George Zimmerman, so who cares? It would be wrong to do that. Your decision, as we talked about during jury selection, your decision must be based upon the law and the evidence in this case. That's the way we work. That's the way the system works. That's the way our justice system works. It must be based upon the law and the evidence. No matter who the parties are, not upon emotion or not upon dislike of someone or anyone. Just the law and the evidence. That's what your decision must be based upon. Now let me make a few other quick observations and then I'll sit down. I'm almost done. And I'm kind of touching upon a few things here and then, just some closing finishing thoughts, additional observations. Please note that Mr. Zimmerman flagged down a police officer very quickly. It was just a couple of seconds after the shooting that he saw that Lake Mary police officer driving up to Officer John Call and flagged him down. As between George Zimmerman and Matthew Apperson, as between the two, it was George Zimmerman who contacted the police before Matthew Apperson, as between the two. And you remember the testimony of Michelle Hernandez when Mr. LaFay was asking her questions about the interview that they conducted and what they said to Mr. Zimmerman. And once again, this is an evidence that they said to him that they considered him only the victim in this case. Those are the investigators at the Lake Mary Police Department. Additionally, please, you cannot hold it against Mr. Zimmerman for wanting an attorney, for having a lawyer. He had the right to do that, and you can certainly understand why, or it's certainly understandable why he wanted to speak with his lawyer, considering his previous legal entanglements. Actually, right here in this courtroom. So it's perfectly understandable, perfectly reasonable to do that, and please do not hold that against him because he called his lawyer when he knew that there was a very serious situation going on. You cannot hold that against him, please. And one other observation. Look at these photographs. These are the photographs of Mr. Zimmerman's right arm. You see the injuries? And you'll have a chance to take these back to you in the courtroom. And there's a specific reason why I'm showing these photographs to you right now. The injuries are to his right forearm. Well, let me ask you something. Aren't these injuries consistent with Mr. Zimmerman driving and then the shot impacting that glass and then spraying glass forward towards and on him, instead of him pointing a gun at Mr. Apperson? This is his right hand, right arm. He would have been driving. The bullet blasts the window. It sprays some glass and cuts his forearm. Please consider that. Completely inconsistent with him pointing a gun at someone. And as far as Mr. Apperson calling the police and telling them at the scene over and over again that Mr. Zimmerman pointed the gun at him and that he was just defending himself. Well, he knew, Mr. Apperson knew that he would be identified. Mr. Apperson knew that George Zimmerman knew him and that eventually the police would be coming to him, Mr. Apperson. So what do you do to divert suspicion from yourself? You go to the police immediately and you claim that you're the victim in the case. It's kind of like a preemptive strike. He knew what he did. He knew that the police would be eventually coming to him. He knew that Mr. Zimmerman could identify him. So what do? As fast as you can, you go to the police and you claim it was him, not me. And that's exactly what Mr. Apperson did in this case. Now, the last thing I want to quickly talk to you about is the what are called lesser included offenses and the verdict forms. There were three. Well, first, let me just very briefly talk about a lesser included offense. In this case, there are three charges. Two of them contain what are called lesser included offenses that you'll have a choice to look at. It's simple what a lesser included offense is. A lesser included offense is, by definition, a less serious offense that is, by definition, included within the greater offense. So, by definition, if you commit the greater offense, you also commit the lesser offense. But the reason why I'm saying that to you is, you go back and you deliberate and you start thinking, and deliberate on the case, and, based upon the evidence, we think Mr. Apperson is guilty of the main charges. But the prosecutor a few moments ago told us if he's guilty of the main offense, then by definition, he's guilty of the other offenses. So we kind of like a choice to which one to pick. Well, Judge Nelson is going to instruct you that you should find the defendant, Mr. Apperson, guilty of the greatest offense that has been proved beyond a reasonable doubt. And that's the reason why I talk about lesser included offenses. You'll see on the first count, there are two lesser included. There's actually one lesser included offense, and the main charge is attempted second-degree murder. There's the lesser included offense on that count of what's called attempted manslaughter by act. And you'll get a definition of that. There'll be a jury instruction. You'll have these things to take back with you, by the way, so don't feel you need to commit these things to memory. You'll have a copy of the verdict, of the jury instructions with the verdict form, and you'll get a definition of attempted manslaughter. The lesser included offense there's no lesser included offense for count 2, which is shooting into an occupied vehicle. And there are two lesser included offenses for the third count, aggravated assault. The main charge, aggravated assault, and the two lesser included offenses are what are called improper exhibition of a firearm. You'll get a definition of that, a written definition, and what's called simple assault. And you'll get a definition of that also, a written definition. Also note on the the verdict form, for two of them, you'll have what are called special findings of fact. And it's pretty self-explanatory, but please read it very carefully so there are no mistakes made. It will give you a choice of whether or not to find that Mr. Apperson possessed and discharged a firearm during the course of the crime. And that you'll see with respect to count 1 and with respect to count 3. The attempted second-degree murder and the aggravated assault. And you'll see it on the verdict form. It's pretty self-explanatory, but please read those over carefully so you can see clearly what you're being asked to do and what the choices are. So I'm going to stop now to give Mr. Lefebvre an opportunity to make his argument. Please listen to what he has to say very carefully. And then after Mr. Lefebvre makes his argument, I'll have a chance to briefly respond to it. So thank you very much.